Hello, good afternoon, and welcome to An Academy, a one-stop destination for the English medium civil services aspirants. Welcome to a marathon session on the Doctrine of Basic Structure, where we will explain the landmark Kesavananda Bharati versus State of Kerala judgment of 1973. But first up, why this session? And listen to me carefully. We are launching a new batch for CSE 2025 aspirants. The name of the batch is the Achievers Batch. The course starts June 25, and we will start with Indian polity, the subject that I shall be taking. But students should know what to expect in that batch. The students should know how do we teach, how do we deliver content, whether the content is exam-oriented or is a deviation from the real examination. That's the purpose of the session. So by attending this session, you will get an idea, a full idea of how the classes shall be conducted, what sort of delivery of content would take place, and whether, and that's for you to judge, which is very important, that's for you to judge whether this course can be of some help to you or not. This batch, which starts June 25, there is a massive rebate on the course fee for 15 months of subscription. The course fee is at 24,999, and I'm told that the rebate on the course fee, this discount period ends today. Should you wish to enroll in this program, enroll now, because after that I'm told the course fee is going to be increased. But let's understand this topic in great detail. The year was 1973, and 1973 is considered to be an eventful year in the history of independent India. How? The year was 1983 when Bollywood gave us its first chocolate hero. Rishi Kapoor made his debut in the movie Bobby. 1973 was the year when efforts were made to save tigers. Project Tiger was launched in 1973. 1973 was the year when Mysore was renamed as Karnataka. Particularly significant is a date, 24th April 1973. On this date, Sachin Ramesh Tendulkar was born, the man who saved India's cricket. But for the civil services examination, this date, 24th April 1973, is important because on this date, a historic landmark Kesavananda Bharati judgment was delivered by the Supreme Court. 13 judges heard this case, which is the highest strength of judges hearing a particular case in the history of independent India. This case was heard for 68 days, again a record. Now you might argue, sir, there are cases which are pending for 20 years, 15 years. So how can you say the longest running case in the history of independent India is this Kesavananda Bharati judgment, which was heard for 68 days? Those cases are pending trial. But once the trial starts, for how many days was a particular case heard? The longest time a case was heard was this case, Kesavananda Bharati, which was heard for 68 days. The judgment was in 703 pages. The Attorney General of India, who had to present the viewpoint of the central government, the union government before the Supreme Court, made a comparison of 71 constitutions of the world. And this case was decided by a wafer-thin majority. 7 judges were in favor, 6 judges were against. So this landmark case in the history of independent India, Kesavananda Bharati versus State of Kerala 1973, was heard for 68 days. The judgment runs into 703 pages. The 13 judges heard this case. And the fundamental question, the basic question that the court had to answer was, is the power of Parliament supreme, that it can amend any provision of the Constitution? Is there a limitation on the powers of the Parliament in amending the Constitution? Or does the Parliament of India have uncontrolled power in amending any provision of the Constitution? That was the basic question that the court had to answer. And it was in this judgment that Supreme Court propounded a doctrine known as basic structure. Supreme Court said, yes, there is a power available with the Parliament that it can amend any provision of the Constitution except those which are part of the basic structure. Parliament has the power to use Article 368 of the Constitution and amend any provision of the Constitution save basic structure, except basic structure, without touching the basic structure. But how did we reach to that point? For that, we will have to go back in time and understand the history of this. But first thing that you must understand is, what is a constitutional amendment? Adding an article to the Constitution is an amendment to the Constitution. Making any change to the Constitution is an amendment. You repeal something from the Constitution, it's an amendment. You add a comma, a full stop, make any change to the Constitution, that is an amendment. And that is how questions have also been asked in your examination. For example, this was the question asked in the recently concluded Prelims 2024. As per Article 368 of the Constitution of India, the Parliament may amend any provision of the Constitution by way of, it can add something to the Constitution. It can vary something in the Constitution, modify something in the Constitution. It can repeal something as well. 1, 2, and 3 is the right answer. So long story short, what is a constitutional amendment? Using Article 368 of the Constitution, Parliament may modify any provision of the Constitution, add something to the Constitution, delete something from the Constitution without altering the basic structure. And what is that basic structure? We will discuss slightly later. But if this is what constitutional amendment is, you might be wondering as to what is the need to amend the Constitution. Why should we amend the Constitution? For that, let's understand the viewpoints of two important personalities. First up, the first Prime Minister of India, Pandit Nehru. Pandit Nehru said, what is a constitution basically? Constitution is a document of people's faith and aspirations. Remember, we were a colony of the British. We were not governed by ourselves. Laws were being made in the British Parliament for Indian citizens. You would remember there was a time when an Indian judge cannot try Europeans. So we aspired for democracy, but we were not given. We aspired for freedom, liberty, equality, fraternity, dignity of an individual, but we were not given. Why? Because we were a colony. We were ruled by an alien power. But then cabinet mission was sent in 1946, which promised us a constituent assembly. And it is this constituent assembly which drafted the constitution for the independent India. But this constitution begins with preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, so on and so forth. That is our aspiration. So this constitution is not the gift of a foreign power. This constitution is not the gift of the United Nations. This constitution is the gift of people to themselves. That's why the constitution, the preamble, starts with this phrase, we the people. We have gifted this constitution to ourselves. And what is this constitution? It is a document of our faith and aspirations. Aspirations keep on changing. What could have been the aspiration of the people of India in 1950 may not have been the aspiration of the people of this country in 1970s. May not be the aspiration in 2024. And what are our aspirations right now may not be the aspirations of the people who will come after us in 2050, in 2060. So this document, which is the Constitution, which is the document of people's faith and aspiration, as aspirations keep on changing, this document also has to reflect to those changing times and aspirations of the people of this country. That is the need. Why we need to amend the Constitution, because Constitution should not remain a rigid document which is not capable of change. Otherwise, it will be like a religious text which you can't alter, which you can't change. That's what Pandit Nehru said. Constitution should not be so rigid that it cannot be adapted to the changing needs of national development and strength. And he made a very important point, and I will come to that point later as well. He said any popular demand for changing the system should be capable of realization. Whatever is the popular demand of the people of this country, that should be capable of realization by suitably amending the constitution bases the needs and aspirations of the people of India. Because after all, the constitution is a document of people's faith and aspirations. Let's come to the other viewpoint of Dr. Ambedkar. I am teaching you right now. Some of you would love this lecture. Some of you would be neutral. Okay. Some of you would hate me. What is he talking about? I am not able to understand, because it's not possible to satisfy 100% of the people, 100% of the populace. That's what Dr. Ambedkar also said. It may be possible, said Dr. Ambedkar, that you're not satisfied with the constitution I have written. If you're dissatisfied with this constitution, do one thing. Get 2/3 majority in the parliament and change the constitution. After all, these people who will be elected to the parliament will be elected on the basis of universal adult suffrage. All the adults will vote to elect their representatives to the parliament, and if parliament decides by 2/3 majority that you want to change, alter, modify the constitution, you are free to do that. But if you cannot get 2/3 majority, then we can assume that only you are dissatisfied. Your dissatisfaction is not shared by the larger public, by the wider public. Long story short, if you want to change the constitution, get 2/3 majority and amend the provisions of the constitution using Article 368, and that's how you can change the constitution. That is the need of a constitutional amendment. So what have we discussed till now? What is a constitutional amendment? And we discussed one PYQ. What is the need for a constitutional amendment? We discussed the viewpoints of Pandit Nehru and Dr. Ambedkar. Now come to the moot point. How constitution came to be altered, modified and amended. For that, just keep in mind that what is the procedure that you need to follow to amend the constitution. That procedure is mentioned under Article 368 of the Constitution. And to understand that, let's go back in time. You need to understand two important directive principles of state policy, 39B and 39C. If you recall, we had Mr. B.N. Rao, who was the constitutional advisor to the Constituent Assembly, to the drafting committee of the Constitution. He was not in favor of keeping directive principles as non-enforceable part of the Constitution. Because what are directive principles? These are basically not enforceable in a court of law. These are positive obligations on the state. It shall be the duty of the state to implement these directive principles of state policy. But the state has been given time. The state has been given discretion. Whenever you want, you can implement these directive principles of state policy. Mr. B.N. Rao was not in favor. He wanted these directive principles to be part of the enforceable part of the Constitution, just like fundamental rights. If the state does not implement these directive principles, you should have the option of going to the court, knocking the doors of the court. But nevertheless, DPSPs were unenforceable. But two directive principles, 39B and 39C. What is 39B? 39 clause B talks about that whatever material resources we have in a community, land is one material resource. These material resources should be so distributed so as to lead to common good.
It should subserve the common good. In a sense, the land that we have, which is a material resource of a community, it should not be in such a manner that only the few segments of our society are controlling it. It should be so distributed so that it leads to larger public good. 39 clause C, it talks about the operation of our economic system and means of production should not result in the concentration of wealth to a common detriment. That means Article 39 clause C prohibits concentration of wealth to a common detriment. Concentration of wealth in fewer hands. This was a promise of the Congress Party when it was fighting for India's independence, that once we get independence, we will implement land reforms. Once we gain independence, we will abolish the zamindari system. Because zamindars would control massive areas of land. There is concentration of wealth in fewer hands. We need to ensure that this land, which is a community resource, which is a material resource, should be so distributed so that it leads to larger public good. And for that, Pandit Nehru's government got the parliament together and enacted Land Reforms Act and Zamindari Abolition Act. Bihar also did this. Some other states also did this because they wanted to implement directive principles of state policy. Patna High Court said unconstitutional. What Patna High Court said? Patna High Court said this Bihar Land Reforms Act, which has ensured, which provides for that this land should be distributed amongst the landless. This is unconstitutional. Why? Because it violates Articles 14, 19 and 31. Article 40, a right to equality. Article 19, Clause 1, Clause F, which gave every single citizen a fundamental right to acquire property and dispose of property as well. Article 31, which allowed the state to acquire property, but for that compensation had to be provided. Since no compensation was provided to those zamindars whose lands were confiscated and distributed amongst the landless, matter went to the Patna High Court. Patna High Court said it is unconstitutional. Now, what do we do in this case? This was not the only case. Madras government issued an order that we shall reserve seats for the members of SC and ST community in government, engineering and medical colleges. Matter went to the court. This case came to be known as Champak Dorai Rajan versus State of Madras, 1951. Supreme Court said this Madras government order is unconstitutional. Madras government was asked, what are you trying to do? Madras government said, we are trying to implement directive principles of state policy. Which one? Article 46. What does it say? That we have to take into account the claims of the members of the SC and ST community when we are advertising jobs, when we are providing education in educational institutions. Supreme Court said, but directive principles are inferior. Fundamental rights are superior. So Land Reforms Act, Zamindari Abolition Act, unconstitutional. Then what do? Parliament got together, amended the constitution, and that came to be known as the First Constitutional Amendment Act, 1951. On one hand, Article 15, Clause 4 was added. Because what is Article 15? There can be no discrimination on the grounds only of religion, race, caste, sex, place of birth. On these grounds, there can be no discrimination. Merely on these grounds, there can be no discrimination. An exception was added that there can be discrimination for those who are socially and educationally backward, which means SCs and STs in educational institutions. This was done by the first Constitutional Amendment Act. But something more important. Article 31 capital A was added. And this Article 31 capital A spoke of agrarian reforms. Since zamindari is to be abolished, since land reforms are to be implemented, but if we try to implement land reforms, if we try to abolish zamindari system, the courts have said that you can't violate Article 14, 19, 31 because these are fundamental rights. Let's add an exception. When we are implementing agrarian reforms, during this process, if Article 14, 19 and 31 is violated, the law should not be declared unconstitutional. That means an exception was created. Specifically for these laws related to agrarian reforms, whenever such a law is passed, even if such a law violates 3 fundamental rights under Articles 14, 19, 31, merely on this ground, the law should not be declared unconstitutional. Then Article 31 capital B was added. Although one of the most significant legal luminaries in India, Justice Rohinton Fali Nariman, he says that this was not needed. Pandit Nehru got this constitutional amendment, got this article added to the constitution on the recommendation, on the suggestion of the Advocate General of the state of Madras. Because he recommended to Pandit Nehru that forget about agrarian reforms, there should be something in the constitution where any law that we place should be immune from judicial review. No courts in this country should challenge the validity of that law. And that's how 9th schedule got added to the constitution. And any law that is placed in 9th schedule, there can be no judicial review. This was done in 1951. I will repeat. First Constitutional Amendment Act 1951 was triggered because of Patna High Court order, which said you can't implement land reforms and abolish zamindari system because you are violating fundamental rights guaranteed to us in the Constitution under Article 14, 1931. Champak Dora Rajan, which said directive principles are inferior, fundamental rights are superior. Then how do we implement 2 very important directive principles, 39B and 39C? For that, the first Constitutional Amendment Act, what it did, it introduced Article 15, Clause 4, and at the same time, it added Article 31, capital A, capital B, added 9th schedule to the Constitution. It is this 31B which provides for the 9th schedule of the Constitution. And any law which is placed in 9th schedule, there is no judicial review. And whenever the government will try to implement agrarian reforms, even if those policies, those laws violate fundamental rights under Article 14, 1931, the law merely on this ground shall not be declared unconstitutional. This Constitutional Amendment Act was challenged in the court. Shankari Prasad Deo versus Union of India, 1951. The court was asked, my lord, look at Article 13 of the Constitution. What is Article 13? Sir, look at Article 13, Clause 2 specifically. Sir, what is that? Sir, it says the state shall not enact any law to delete or abridge a fundamental right. What does that mean? Sir, the state has been prohibited from enacting any law. And through this law, you cannot delete, you cannot modify any fundamental right. The Attorney General was asked, what is the petitioner saying? Sir, I can explain. Sir, what? Sir, look at the interpretation of this law under Article 13, Clause 3. So what are you saying? Sir, yes, it is true that Article 13, Clause 2 says the state shall not make any law, law is the word, to delete, modify, abridge fundamental right. But what is this law? This law has been explained in Article 13, Clause 3. What does that mean? Sir, law says under Article 13, Clause 3, that law means rules, notifications, ordinances, bylaws, customs, usages. So, sir, it does not mention Constitutional Amendment Act. What are you trying to say? Sir, Article 13, Clause 2 says the state cannot make any law. And what is that law? That means through ordinances, through rules, through customs, through usages, through regulations, you cannot delete, modify, abridge fundamental right. But you can do this only by passing a Constitutional Amendment Act under Article 368. Why? Because law is different, Constitutional Amendment Act is different. Through a law, you cannot delete, modify, abridge fundamental right, but through a Constitutional Amendment Act, you can. Law, which means rules, regulations, notifications, bylaws, customs, usages, you cannot delete, modify, abridge fundamental right. But that is law. That is not the same case with a Constitutional Amendment Act. Using a Constitutional Amendment Act, under Article 368, you can do anything. You can delete, modify, abridge fundamental right. Supreme Court accepted this argument. Supreme Court accepted this argument and said, yes, 31 capital A, 31 capital B, 9th schedule is constitutional. But look at the wider implication. If this is allowed, does that not give Parliament to do anything? To remove all the chapters of fundamental rights, all the articles of fundamental rights, any provision of the Constitution by using Article 368. This was Shankari Prasad Deo versus Union of India, 1951, where Supreme Court said law is different, Constitutional Amendment Act is different. Through an ordinary law, you cannot delete, modify, abridge fundamental right. But through a Constitutional Amendment Act, passed under Article 368, you can. This was the position which continued. Then came another landmark case, Golak Nath versus State of Punjab, 1967. Supreme Court took a complete U-turn. Supreme Court said no. Law includes a Constitutional Amendment Act. Sir, what are you saying? When Article 13, Clause 2 says, state shall not enact any law through which you can delete, modify, abridge fundamental right, law should be interpreted as Constitutional Amendment Act as well. Because Constitutional Amendment Act also is what? It's a law. So even by using Article 368, even by enacting a Constitutional Amendment Act, you cannot delete, modify, abridge fundamental right. What does that mean? That means these fundamental rights are beyond the amending powers of the Parliament. You can't dare touch these fundamental rights, said the Supreme Court, 11 judges of the Supreme Court in Golak Nath versus State of Punjab, 1967. The Attorney General asked the court, my lord, I have a question. Said, yes. Said, look at Article 368. It gives us, the Parliament, the power to amend the Constitution. How can you say fundamental rights are beyond the amending powers of the Parliament? Supreme Court said, no, you are mistaken. Said, how? Said, look at the title of Article 368. At that time, Article 368's title was Procedure for Amendment. The Supreme Court said, read it. The title of Article 368 is Procedure for Amendment. It does not confer power on the Parliament to amend the Constitution. The Attorney General said, but if this is the procedure which is mentioned under Article 368, this procedure is for whom? This procedure is for Parliament. We have to follow this procedure to amend the Constitution. Supreme Court said no. You have to maybe set up a constituent assembly. set up a constituent assembly, and let that constituent assembly use the procedure under Article 368 to amend the constitution. You, Parliament, you only have ordinary lawmaking power. And through that, you cannot delete, modify, amend fundamental rights, abridge fundamental rights. Fundamental rights are beyond the amending powers of the Parliament. Set up a constituent assembly, and that constituent assembly can modify, abridge fundamental rights, but you can't. So 1951, Shankari Prasad Deo, Parliament can do anything. Use Article 368, do anything, make any changes to the Constitution, any changes to the fundamental rights chapter. But Golak Nath case in 1967, Supreme Court said no. There is a limitation on the Parliament. Parliament cannot amend fundamental rights. That is beyond your amending powers. Something else happened after that. Indira Gandhi was the Prime Minister. Golak Nath judgment was delivered. It was a loss for her. And there was one legal luminary who fought this case, and that name is Nani Palkhiwala. Indira Gandhi's government did something else. What did she do? In 1969, she nationalized banks. What is bank nationalization? The argument of the government was that there are these private banks who give credit, who give loans, who are catering to the needs of the wealthy, the capitalist class. But the poor are deprived of access to loans, to credit. And the only way in which we can empower the people, implement our socialist programs, is to nationalize these banks, convert these private banks into the government banks. 14 banks were nationalized. Matter went to the court. Supreme Court said this is unconstitutional. And this case also was fought by Nani Palkhiwala. To be fair here, the court upheld the right of the government to nationalize banks. The court said, yes, the government has the power to nationalize banks. You can do that. But for that, you have to pay compensation. The government said, my lord, yes, we are paying compensation. It's not that we are converting these private banks into nationalized banks and we are not providing compensation. We are providing compensation. The court said, yes, you are providing compensation in the form of bonds, and these bonds will mature after 10 years. And if you are providing such a compensation in the form of bonds, which will mature after 10 years, this is not a fair compensation. And if it is not a fair compensation, it violates Article 14, it violates Article 19, it violates Article 31 of the Constitution. Golak Nath judgment was against the government. The government lost. Bank nationalization judgment, it was against the government lost. And then came the third important judgment, again petitioned by Nani Palkhiwala, and that judgment was in case of privy purses. There were more than 562 princely states during the British rule, when British was governing India. Then India was to be given independence. What will happen to these princely states? These princely states were given options. Either you can join India, or you can join Pakistan, or you can stay independent. Sardar Patel, also known as the Man of Unity, played a pivotal role, a very important role, in ensuring that majority of these princely states merge with the Union of India. And he promised them something in the form of privy purse. What did he promise? Dear princes, you have your vintage cars, you have your bungalows, you have your gold and pearls. Keep them. We don't need it. On top of that, we will give you a purse. like a dad is giving to his children, or a mom is giving to her children. Pocket money. No questions asked. Spend this money the way you want. A percentage of your state's, your princely state's revenue, we will give it to you. Which ranged, for example, for Hyderabad, the ruler of Hyderabad, he would be given 73 lakhs as privy purse per year. It was a big amount at that time. And the rural of Kakodia was given 62 rupees. So it depended upon the revenue generated by that privy purse previously. But Indira Gandhi realized that there are these princes who are getting money from the government in the form of privy purse, and they're using that money to contest elections against me, particularly the royals in Rajasthan. She asked the president, advised the president, promulgate an ordinance and deprive these princes of these features, benefits. Matter went to the Supreme Court. Supreme Court said this is unconstitutional. So something strange is happening now. From 1951, when the Supreme Court said power is with the parliament, that it can use Article 368 to make any change to the constitution, to the Golak Nath judgment, where the court is saying fundamental rights are beyond the amending powers of the parliament. That's the first defeat. Second, Bank Nationalization Act, unconstitutional. State, you have the right to nationalize banks, but you have to provide compensation which is fair. And this compensation that you are giving them in the form of bonds, which will mature after 10 years, it is not a fair compensation, unconstitutional. And through this ordinance, if you're depriving the princes of their titles, that is also unconstitutional. But Indira Gandhi was not somebody who would take the defeat lying down. She got the parliament together, amended the constitution, the 24th Constitutional Amendment Act, 1971. The first feature of this constitutional amendment was, whenever a constitutional amendment bill is passed by both houses of the parliament, it is sent to the president. President has only one option: give her assent. Sign it. You can't use pocket veto. You can't use suspensive veto. You can't use absolute veto. All you have to do, when a constitutional amendment bill is passed by both houses of the parliament, sent to the president shall give his assent. There was another option: or you resign. But you have to give assent. That's the only power that you have. That's the only role that you have vis-a-vis a constitutional amendment bill. And then Article 13, Clause 4 was added. What is Article 13, Clause 4? Remember when I told you that Article 13, Clause 2 says the state shall not enact any law to delete, abridge, modify a fundamental right. And the definition of what is law is mentioned under Article 13, Clause 3. Law is rules, notifications, bylaws, customs, usages, ordinances, regulations. But fourth clause was added. Nothing in this article shall apply to an amendment to the Constitution made under Article 368. Nothing in this article. In this article, there is a limitation that their parliament, their state, you cannot delete, modify, abridge fundamental right. This does not apply if you are using Article 368 to amend the Constitution. Which means you are saying what? Constitutional Amendment Act is different, law is different. Which means through law, you cannot make any changes to fundamental rights. But through Constitutional Amendment Act, under Article 368, you can do that. Somebody advised Indira Gandhi, Madam, but do you know what the Supreme Court said in Golak Nath case? Was it what? Supreme Court said that Article 368 does not give you the power to amend the Constitution. It only talks about procedure for amendment. Indira Gandhi said, don't worry. I said, why? Because we will amend Article 368 itself. We will change the title of Article 368. If it was saying procedure for amendment, now the headline would be, the title would be power of the Parliament to amend the Constitution and the procedure therefore. Now, isn't this the power given to us by the Constitution because we have amended the Constitution? So, 24th Constitutional Amendment Act, it amended Article 13, it amended Article 368, it changed the title of Article 368, giving Parliament the power to amend the Constitution, and at the same time, it added another clause in Article 13, which says, nothing in this article shall apply to an amendment to the Constitution made under Article 368, which means if there is a limitation on the state that you can't delete, modify, abridge fundamental rights by enacting a law, that is an ordinary law, that's a regulation, that's a rule, that's a custom, that's a usage, that's an ordinance, not a Constitutional Amendment Act. Through a Constitutional Amendment Act, you can delete, modify, abridge a fundamental right. This was 24th Amendment. 25th Amendment, Parliament is doing something else. Parliament is amending Article 31 Clause capital C. What is Article 31 capital C? It says if the Parliament wants to enact a law, listen to me carefully, and through this law, Parliament wants to give effect, implement two directive principles of state policy. Which are these two directive principles of state policy? Article 39B and Article 39 Clause C. And then if this law also violates Article 14, 19 and 31, this law cannot be declared unconstitutional. And in fact, there can be no judicial review of such a law. Sir, what is this? What is happening? Granville Austin, who took a look at the Constitution, the developments of the Constitution, said this period was very, very different period. Unusual period. Because right after that, emergency was also imposed. If Golak Nath judgment, Supreme Court says, Parliament does not have the power to make any changes to fundamental rights. Fundamental rights are beyond the amending powers of the Parliament. Bank Nationalization Act unconstitutional. The title of the princes revoked through an ordinance, that is unconstitutional. So 3 defeats. Indira Gandhi's government was smarting under 3 defeats. All these 3 cases were fought by Nani Palkhiwala. But Indira Gandhi was not somebody to take it lightly. Got the Parliament to amend the Constitution, added Article 31 capital C, and now because of this constitutional amendment, 2 directive principles were given superiority, were given primacy over 3 fundamental rights, 14, 19 and 31. If in Champak Dore Rajan case, Supreme Court said directive principles are inferior, fundamental rights are superior. Now what Parliament is doing? Giving superiority to 2 directive principles over 3 fundamental rights. And this constitutional amendment further says such a law cannot be even challenged in a court of law. There can be no judicial review. This was 25th Amendment to the Constitution, 1971. And 26th Amendment did something else. We made a mistake, said the government. We promulgated an ordinance, and through that ordinance we deprived princes of their title. And then through that process we wanted to deprive them of their privy purse as well. We should not have done that through an ordinance. Let's amend the Constitution. Let's use Article 368. And through this 26th Constitutional Amendment Act, privy purses was abolished. But something else happened, and this time it is Kerala. Kerala is a unique example. Is there any communist state in the world? None. Although China claims to be a communist state, Russia claims to be a communist state, Cuba and other Latin American countries claim to be communist states, but they're not. Even if they are communist states, all these communist states have erupted or have been established through revolution, never through democratic means. But if anywhere in the world a communist government was formed through democratic means, through elections, that was the Indian state of Kerala. When the communists formed the government in Kerala in 1959, it is argued that even CIA, Central Intelligence Agency of United States, they were taken aback, they were shocked. Because their entire foreign policy was focused on containing communism. They wanted to expand their influence of capitalism. So Kerala was under a communist government. After that, the communist government chief minister was dismissed as well. President's rule was invoked in the state of Kerala, which is considered to be one of the black spot on the work of Pandit Nehru. But be that as it may, Kerala tried to implement land reforms effectively. Although it is argued that there are two states in India. There have been two states where land reforms were effectively implemented. One was Telangana, the other was Jammu and Kashmir. Kerala passed a law under which it imposed limitations on land known as land ceiling. This is the amount of land that any household can acquire, hold on to. If you possess land in excess of this, it will be distributed amongst the landless. Later on in 1970, the Kerala government did something else. Kerala legislature did something else. What it did? It even included religious institutions. Even religious institutions who have land beyond the ceiling, that land can be confiscated and distributed amongst the landless. That's how they wanted to implement the land reforms. There were multiple challenges to this. And ultimately, the Kerala government requested the centre that, can you please do one thing? Said, what? Can you place this Kerala Land Reforms Act in the 9th schedule of the Constitution? Because whenever a law is placed in 9th schedule, automatically there is no judicial review. So anybody challenging this Kerala Land Reforms Act cannot challenge it because the law is placed in 9th schedule. This 24th Amendment, this 25th Amendment, this 29th Amendment was challenged by somebody known as Kesavananda Bharati. Kesavananda Bharati, a young man in his 20s, the head of a mutt in Kasaragod district in Kerala. He was also the owner of various sugar mills in Kerala. And ultimately, his property could also have come under this. He was head of a religious institution, which had a lot of property as well. But though that property, if it is beyond the ceiling, could have been acquired by the state and distributed amongst the poor, distributed amongst the landless. Kesavananda Bharati wanted to challenge this. And various other important events had taken place. 24th Amendment, 25th Amendment, 29th Amendment. Now the question was, who will argue this case? Mr. Chagla, who was once the Supreme Court judge, he was considered to be fit to argue this case, but he said, I can't do that because I am now in my old age. I cannot do this. Then there was another terrific constitutional lawyer, Mr. Daftari. He said, why don't we ask Nani Palkhiwala to come? Nani Palkhiwala was automatically a first choice because he defeated the government when it comes to Privy Purses case, bank nationalization, Golak Nath. Nani Palkhiwala was away from country as well, but then he was brought. And he urged Kesavananda Bharati that forget about Article 14, forget about Article 19, forget about Article 31. We should file this case under Article 26 of the Constitution. What is Article 26? The fundamental right of any religious denomination. What you can do? You can establish, manage, and administer religious institutions of your choice. You can acquire property, you can dispose of property for furthering your religious interests. But Nani Palkhiwala and Kesavananda Bharati never met. Perhaps the rare instance where the client is not meeting the lawyer. And Nani Palkhiwala is now thundering before the court. Other state governments also petitioned, what is this parliament doing? You're violating our rights. You have changed the constitution. Various other individuals also challenged. But since the first case was filed by Kesavananda Bharati, it came to be known as Kesavananda Bharati versus State of Kerala, 1973. Almost all the states became the respondents in this case. They also had to present their point of view. Various other petitions were filed, and all these petitions raised one common issue. One basic issue. Is the power of Parliament supreme that it can amend any provision of the Constitution? Now, Nani Palkhiwala is arguing before a 13-judge bench of the Supreme Court. And Nani Palkhiwala begins with something called Doctrine of Implied Restriction. Or implied limitation. What is this doctrine of implied limitation? When they were preparing for this case, they happened to go through some of the writings of a German philosopher. Because in Germany, as well as in Japan, there are explicit provisions which say that these are the areas which you can't change in the Constitution. And that German professor and Nani Palkhiwala is basically saying, let's argue on this matter through the doctrine of implied limitation. And what is this doctrine of implied limitation? If you look at the plain reading of Article 368, just read it. Power of Parliament to amend the Constitution and the procedure therefore. Or even before that, procedure for amendment of the Constitution. And it talks about the ways that this bill has to go through before Constitution can be amended. So there was no explicit limitation on the powers of the Parliament in the original Constitution. This is where it becomes interesting. Constituent Assembly. Who gave this Constituent Assembly? Cabinet mission, which later on failed as well. So basically, Indian Independence Act gave us the provision of Constituent Assembly after Pakistan was separated. But these people who were there in the Constituent Assembly, they were also elected, but the right to vote was restricted. All adults did not have the right to vote. You should have been a matriculate to vote. You should have had a property above a certain level. Then you could have voted. because this right to vote was not available to anybody. So if we say this constitution is the document of people's faith and aspirations, but people were not directly electing the members of the Constituent Assembly, that is why they left it to the future parliament. Let's first enact the constitution and later on let the parliament, which will be elected on the basis of universal adult suffrage, where there will be no discrimination between man and a man in a political affair, let them decide the contours of this constitution. That's why procedure was provided under Article 368. But there was no limitation, no explicit limitation on what Parliament could or could not have done. And Nani Palkhiwala starts with doctrine of implied limitation. My lord, if I have to amend the constitution, I will use Article 368 to amend the constitution. I am the Parliament. One by one, can I repeal every provision of the constitution so that we reach a point that there is no constitution? Can it happen? What are you saying? If I have the power to amend any provision of the constitution, what is amendment? Make any changes to the constitution. Can I use Article 368 one by one, repeal all the articles, parts, schedules of the constitution so that there is nothing left? Can we use Article 368 of a constitution to create a constitution-less state? Can it happen? No. That means, what are you trying to say? That there is a limitation. Forget about this limitation. We have Article 21 of the Constitution. And what is the significance of Article 21? Some constitutional experts say this is the heart and soul of fundamental rights. Heart and soul of Part 3 of the Constitution. Because it is this Article 21 which makes enjoyment of every other fundamental right possible. Because fundamental rights have exceptions, have restrictions. Article 14 is not an absolute fundamental right. There are exceptions. Article 15, Article 16, your freedom of speech and expression, there are restrictions. But let's assume that there are no restrictions to your fundamental rights. Article 14 is absolute, 15 is absolute, 16 is absolute. Your freedom of speech and expression is absolute. But you lack one fundamental right, which is right to life. There is no right to life. Then what will you do with these fundamental rights? You can't enjoy these fundamental rights. Because it is this Article 21 which makes enjoyment of every other fundamental right possible. Can, my lord, tomorrow Parliament use Article 368 and remove Article 21? The first thing that I am telling you, can we use Article 368 one by one, repeal every provision of the Constitution so that there is no Constitution left? Can it happen? Second, can Parliament use Article 368 to remove Article 21? Or forget about that, can we use Article 368 to gift our country back to the Mughals? Give this country back to the British? Can we do that? Or forget about it. Can we use Article 368 and delegate? This is the most serious thing. Delegate all the amending powers to executive. We are saying, forget about legislature. We will give this amending powers to the executive. Can it happen? You have to say something, because there is something called implied limitation. Because if there is no limitation, Parliament can do this as well. Parliament can use Article 368 and say, from tomorrow, executive will have the power to amend the Constitution. What stops a government from saying that the term of the Lok Sabha is not 5 years, it is 50 years? Can it happen? Using Article 368, it can, because there is no limitation. There is no explicit limitation. This is how Nani Palkhiwala began, using this doctrine of implied limitation. And Supreme Court heard this matter. On one side, we had Mr. Niren De. On the other side, we had Nani Palkhiwala, assisted by Fali S. Nariman and others. We had Mr. Sirvai, who was assisting the state of Kerala as the Advocate General. And Supreme Court said, there is something called basic structure. And curiously, this was not the first judgment where Supreme Court talked about basic structure. In 1965, Justice Mudolkar had also talked about a basic structure doctrine. And he had not invented it either. He was referring to the 1963 judgment given by Justice Cornelius of Pakistan Supreme Court. Yes, Pakistan had a Christian Chief Justice, later on a Hindu judge as well. It was in 1963 that Pakistan Supreme Court said there are some fundamental features of Pakistani constitution which Parliament cannot change, cannot alter. Same logic was used by Justice Mudolkar in 1965, and same logic was used by 7 judges of the Supreme Court, which said, yes, power is with the Parliament to amend the constitution, but it cannot alter basic structure. Rule of law is part of basic structure. Secularism is part of the basic structure. Parliamentary democracy is part of the basic structure. And do you know what? This case, Kesavananda Bharati lost, but Indian democracy won. He lost because the Supreme Court upheld the validity of Article 31 capital C. The Supreme Court upheld the validity of the Kerala Land Reforms Act. The Supreme Court upheld that yes, the government has the right, has the power to impose a ceiling on the urban land, on the land that can be held by a particular individual. So Kesavananda Bharati lost, but Indian democracy won. This was the Kesavananda Bharati judgment delivered by a 13-judge bench of the Supreme Court on the 24th of April 1973. But at the same time, there are those who criticize this judgment. And there are those who praise this judgment. Those who criticize this judgment, what are their grounds? They criticize this judgment on the grounds that this is a judicial innovation. How can judiciary innovate something called basic structure which is not existing in the Constitution? This is what leads to, as Shri Arun Jaitley later on said, not specific to this judgment. So Mr. Arun Jaitley said, tyranny of
want to send a message to
unelected
You have new messages in 35 conversations.
over the elected.
First, JDIC said ICICI Bank acts.
Tyranny of unelected over the elected. These are unelected judges, and they sit on the judgment of those who have been elected directly by the people. And they are proposing something called Doctrine of Basic Structure, limiting the powers of the Parliament in amending the Constitution. There is another important point, and now listen to me carefully. These are not my views, or in a sense, this should not be viewed as my argument, but just for the sake of argument. India is a secular state, right? Right. Now, how do we know India is a secular state? Because that is mentioned in the preamble. That is part of the Supreme Court judgment. In one case, S.R. Bommai versus Union of India, 1994, Supreme Court said secularism is part of the basic structure of the Constitution. So secularism is part of the basic structure, right? But what did Pandit Nehru say? Any popular demand should be capable of realization. That is why we need to amend the Constitution. What if, for the sake of the argument, tomorrow, the majority community in India says we don't want a secular country, we want a Hindu Rashtra. Just for the sake of argument. Don't lynch me for this. Just for the sake of argument. If that is the popular demand, should it not be capable of realization? How can you say no? Even if this is the popular demand, it cannot be capable of realization because there is something called basic structure. And since secularism is part of the basic structure, you can't have a Hindu Rashtra. That goes against the very logic given by Pandit Nehru. Any popular demand should be capable of realization. It's on these grounds that this doctrine of basic structure has been criticized. But there are others who are praising this judgment. They say it is this Kesavananda Bharati judgment which has saved India's democracy. How Indian democracy has been saved because of this judgment can be best understood by the comments given by Mr. Sirvai later, who said, yes, indeed, it was this basic structure doctrine. It was this Kesavananda Bharati judgment which has preserved India's democracy. Otherwise, we would have degenerated into a totalitarian regime or a one-party political system. And to understand that, we need to understand what happened in 1971. Srimati Indira Gandhi was the Prime Minister. Played a very important role in splitting Pakistan. Pakistan was split, Bangladesh emerged as an independent country in this India-Pakistan war of 1971. Prior to that, she was called Gungi Gudiya by Morarji Desai. This doll who can't speak, will she become the Prime Minister? And then this Gungi Gudiya became Durga in 1971 war. Became very powerful. Contested Lok Sabha election from the Raebareli constituency. Her opponent was Mr. Raj Narayan. Raj Narayan approached the Allahabad High Court after the election results, arguing, petitioning, pleading before the Allahabad High Court that Srimati Indira Gandhi should be disqualified. Why? On the grounds of electoral malpractice. What is this electoral malpractice? The allegation was that she was using government machinery to campaign for her elections. She was getting government employees to campaign for her. She was using government money to ask people to vote for her, to canvass for voting. Allahabad High Court said, Mr. Raj Narayan, you are right. Srimati Indira Gandhi, you are disqualified. Srimati Indira Gandhi was disqualified. She approached the Supreme Court. Supreme Court imposed a stay on this judgment, saying you are not disqualified unless and until we will hear this case. But till that time, you can't vote in the Lok Sabha. She became the first sitting Prime Minister to not have been allowed to vote in the Lok Sabha. And it is considered that this was the trigger for imposing emergency in India in 1975. And during 1975, 1976, major changes were made to the Constitution. I mean, we have discussed 42nd Constitutional Amendment Act, how major changes were made in 1976. But particularly significant was the 39th Amendment and 41st Amendment. 39th Amendment said President, Prime Minister, Vice President cannot be disqualified on the grounds of electoral malpractice by the courts. For that we will create another body, but the courts will not take this decision. Maybe we will set up a tribunal which will hear these matters if Prime Minister is to be disqualified on the grounds of electoral malpractice, if a President is to be disqualified, if a Vice President is to be disqualified, if a Speaker is to be disqualified. Judiciary should not take that decision. And it is evident why such a constitutional amendment was made. To save her chair because she was disqualified on the grounds of electoral malpractice. Somebody might have told Indira Gandhi, Madam, what? After you will lose power, these people will not save you. They will come after you. Said, what do? Let's amend the constitution again. 42nd Constitutional Amendment Act was passed, which said if you are a governor, if you are a Prime Minister, if you are the President, no criminal case can be filed against you even after you demit the office. So if you have been appointed as the governor of a state even for one day, you enjoy immunity from all criminal cases for your life. If there was no such thing as basic structure, if the Parliament had the power, supreme power to make any changes to the Constitution, to amend any provision of the Constitution, both these amendments would have been valid. Because Parliament is using Article 368 to do anything. Both these amendments were challenged in the court, and both these amendments were struck down by the judiciary on the grounds that they violate basic structure. Rule of law is part of the basic structure. Free and fair election is part of the basic structure. Because what is rule of law here? Parliament did not say that you can't disqualify President, Vice President, Speaker, Prime Minister on the grounds of electoral malpractice. Parliament only said judiciary cannot take that decision. Then who will take that decision? For that we will set up a body. We will set up. So in this case there is absence of a law. There is no law. Rule of law is part of the basic structure. Hence this is unconstitutional. Free and fair election is part of the basic structure. Hence this is unconstitutional. If there was no such thing as basic structure, we would have degenerated into a single party dictatorship. That is why we say it is this Kesavananda Bharati judgment which has saved India's democracy. But of course, there are those who criticize this judgment as well. Clear? Right now, we have discussed what is a constitutional amendment, what is the need for a constitutional amendment, and what is the history of constitutional amendments and the doctrine of basic structure, the Kesavananda Bharati versus State of Kerala. But even this basic structure has not been defined anywhere. It's based on the judicial innovation. It's based on judicial pronouncements. What is basic structure will be decided by the judiciary, no other entity. And today, if you look at this doctrine of basic structure, if you look at this list, these are the elements broadly which are part of the basic structure. Supremacy of the Constitution is part of the basic structure. Rule of law is part of the basic structure. Free and fair election is part of the basic structure. Parliamentary democracy is part of the basic structure. Independence of judiciary is part of the basic structure. Article 21 is part of the basic structure. Article 32 is part of the basic structure. Secularism is part of the basic structure. Objectives mentioned in the preamble are part of the basic structure. The nature of the Indian state mentioned in the preamble is part of the basic structure. But here comes a problem. What is the problem? Supreme Court said in one of its judgments, independence of judiciary is part of the basic structure. Right? Independence of judiciary is part of the basic structure. And you know, India is perhaps the only country where judges are appointed by themselves. through a system called as the collegium system. And to replace this collegium system, in 2014, the Indian Parliament enacted a constitutional amendment, 99th Constitutional Amendment Act, created a constitutional body called National Judicial Appointments Commission, saying instead of collegium system recommending to the president who could be the judge, who should be the judge of the Supreme Court and High Court, let's entrust this power to this constitutional body called National Judicial Appointments Commission. Matter went to the court. NJAC consisted of Chief Justice of India, two senior judges of the Supreme Court, Union Minister of Law and Justice, and two eminent persons. And these two eminent persons would be selected by a committee consisting of Chief Justice of India, Prime Minister, and leader of opposition in the Lok Sabha, or the leader of the single largest party in the Lok Sabha. So everybody is represented in this committee, in this NJAC. Executive through Law Minister, Judiciary through Chief Justice of India and two senior judges, and the civil society as well. That's how it should have been. But when this matter was heard by the Supreme Court said NJAC is unconstitutional. Why? Because it violates independence of judiciary, which is part of the basic structure. Somebody might have told these judges, but how does NJAC violate independence of judiciary? Because if you look at the original constitution, you were only consulted. Here, you are actively considered part of this process. Because original constitution said all judges shall be appointed by the president after consultation with the Chief Justice of India. Consultation. That doesn't mean whatever Chief Justice of India says, that is binding on the president. It's only consultation. I'm consulting you right now. Am I going fast? Yes, sir. I will still go fast because your consultation, I'm only consulting you. It's not binding on me. If it was concurrence, then if I would have asked, am I going fast? Yes, sir. Should I go slow? Yes, sir. I cannot go fast because your advice is binding on me. It was only consultation in the original constitution. Chief Justice shall be consulted. It was not mentioned that Chief Justice, his concurrence should be taken. So if the original constitution did not violate independence of judiciary, how does NJAC, which gives more power to judges, violate independence of judiciary? Maybe judiciary would have been told this, and they came up with another basic structure. They said primacy of Chief Justice of India in judicial appointments is part of the basic structure. What is this primacy? Basically, it means that Chief Justice of India should have a veto. Any name which is not acceptable to Chief Justice should not be appointed. This veto was not given to Chief Justice of India, and that is what Supreme Court means when it says primacy of Chief Justice of India is part of the basic structure of Indian Constitution. And since that basic structure is getting violated, NJAC is unconstitutional. And that has been the criticism of this basic structure doctrine, saying there is no hard and fast rule as to what are these basic structures of the Constitution. That is why some people say it is the tyranny of unelected over the elected. Unelected judges over the elected representatives. Because these unelected judges get to decide what is basic structure. If that is something that we have understood, now let's look at what is the procedure that Parliament needs to follow to amend the Constitution. For that we need a bill. What is a bill? Bill is a proposal. What is a proposal? We want to add one schedule to the Constitution. That's a proposal. That's a constitutional amendment bill. We want to reserve seats for women in Lok Sabha and legislative assemblies. For that, we need to amend the constitution. But first, we need to give proposal to the parliament. That proposal is a bill, constitutional amendment bill. And look at the flow. This constitutional amendment bill can be introduced in either of the two houses of the parliament. It can be introduced in Lok Sabha first, then Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. Money bill can be introduced only in Lok Sabha. Financial bill can be introduced only in Lok Sabha. That's not the case with a constitutional amendment bill. It can be introduced in either of the two houses. But by whom? There are bills which can be introduced only by ministers, called government bills. There are bills which can be introduced by non-ministers as well, called private members' bills. This constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha by a minister or by a private member without prior permission of the president. Because to introduce financial bill, you need prior permission of the president. To introduce money bill, you need prior permission of the president. To introduce a bill under Article 3, which is reorganization of the states, you need prior permission of the president. But this constitutional amendment bill should be introduced, can be introduced in either of the two houses by a minister or by a private member. Prior permission of the president is not required. And this bill should be passed by both houses of the parliament by special majority. What is the special majority? Majority of the 2/3 members present and voting, and majority of the total membership of the House. If, for example, there are 500 members in Lok Sabha, for example, and out of these 500 members, there are 300 members present. And out of these 300 members present, 250 are voting in favor of this constitutional amendment bill. Will this bill become an act? No. Why? Because although 250 is more than 2/3 of the members present and voting, but it is not absolute majority. It is not majority of the total membership of the House. It should have been 251. Both the conditions have to be satisfied. Majority of 2/3 members present and voting plus majority of the total membership of the House. But sometimes what happens? When one house passes a bill, the other house rejects a bill, there is a deadlock. And to resolve that deadlock, the president notifies something called joint sitting of the two houses. But this constitutional amendment bill, which can be introduced in either Lok Sabha or Rajya Sabha by a private member or a minister, which does not require prior permission of the president, this bill requires special majority in both the houses, that too separately. That means there is no provision of joint sitting. That means if one house rejects a constitutional amendment bill, this bill is dead. Which means the Rajya Sabha has an equal role vis-a-vis Lok Sabha when it comes to a constitutional amendment bill. And once it is passed by both houses of the parliament by special majority, it is sent to the president for signature. It is binding on the president to give his assent. Before 1971, before 24th Amendment, the president could have had the discretion of either withholding assent or suspensive veto or pocket veto. But after 24th Amendment 1971, the president shall give his assent to a constitutional amendment bill. Clear? But if this constitutional amendment bill tries to amend some of the federal features of the constitution, then first, this bill should be passed by both houses of the parliament by special majority separately. And then before this bill could be sent to president for signature, this bill needs to be sent to the legislatures of all states, including Delhi and Puducherry, which are the union territories with legislative assembly. And only when not less than half of the states, at least half of the states, they pass a resolution accepting this constitutional amendment bill, that too by simple majority, only then it can be sent to president for signature. So what are you saying? I'm saying, now let's look at the procedure for amendment. What is the procedure that we need to follow to amend the constitution? For that, what we need, let's take the example of the 106th Constitutional Amendment Act, Women's Reservation Act. Women's Reservation Bill was introduced, which is basically a proposal. The proposal is to reserve seats for women. As nearly as maybe 1/3 of the seats shall be reserved for women in Lok Sabha and legislative assemblies. This bill was passed by both houses of the parliament separately by special majority. Once passed, it was sent to the president for signature, and president shall have to give her assent to a constitutional amendment bill. But what if there is a bill which affects federal features? Which are these federal features? I'll tell you slightly later. But if there are bills which affect federal features, for example, GST, which was a Constitutional Amendment Act, 101st Constitutional Amendment Act. This bill was introduced, passed by both houses of the parliament, but before it could be sent to the president for assent, it was sent to all the state legislatures in India, including Delhi and Puducherry. Once at least half of these states gave permission, approved this constitutional amendment by passing a resolution by simple majority. So states have to approve by simple majority. Parliament has to approve by special majority. Only then it can be sent to president for approval, for assent, and the president shall give his or her assent to a constitutional amendment bill. Clear? Now let's come to the interesting part. The provisions of the Indian Constitution can be amended, modified through three ways. First is by simple majority. And here I will tell you a technical difference. If tomorrow a question is asked in the examination, can Indian Constitution be amended by simple majority? The answer is simple, no. Constitution can be amended only and only by special majority. But there are some provisions in the Indian Constitution which can be changed without using Article 368. That means without amending the Constitution. That means there are some provisions of the Indian Constitution which Parliament itself has said, which Constitution itself has said, you can change us. But these changes shall not be deemed as amendment to the Constitution. Although you are changing something, but those changes are not amendment. When they are not amendment, that means you don't have to use Article 368. What does that mean? Can you make it simple? I'll tell you. Your mom has given you an assignment saying write the summary of this poem in 1 hour. If you are able to complete this in 1 hour, I will gift you an Xbox, for example. You are not completing this in 1 hour. You are completing this in 1.5 hours. Clear? Those extra 30 minutes are not treated as part of the hour. Those are separate. Those are not deemed as part of the first hour. Which basically means that if you're trying to do something, you're making changes to the Constitution, you're doing it, but those changes shall not be deemed as amendment. That means your mother is basically saying, even if you complete your assignment, I'm not going to accept this because you have not completed it on time. In a similar fashion, you are trying to make changes to the Constitution. You are changing the Constitution, but these changes shall not be deemed as amendment to the Constitution. When they are not deemed as amendment, that means you don't need Article 368. Which are these features? For example, formation of new states. A new state, Telangana, is born. That does not require constitutional amendment. It's an ordinary law, passed by simple majority. If, for example, you want to abolish or create legislative councils, you are making change to the Constitution, but these changes shall not be deemed as amendment, which means you don't need special majority. You don't need Article 368. You need simple majority. Simple. You want to increase the number of judges to the Supreme Court, because Article 124 says there shall be a Chief Justice of India and 7 other judges. That was the original Constitution. You can increase the number of judges. Parliament can increase the number of judges without having to take recourse to Article 368. That means you are making change to the Constitution, but that is not deemed as amendment. When it is not deemed as amendment, that means you don't need Article 368, which means you don't need special majority, which means you need simple majority. Simple. These are the provisions of the Constitution which you can change through simple majority, but don't call them amendment. These are not constitutional amendments, because Constitution itself says these changes are not constitutional amendments. And it is this which gives flexibility to Indian Constitution, which tells us that Constitution is flexible. But there are other provisions of the Constitution which can be changed only by special majority. 2/3 of the members present and voting plus majority of the total membership of the House. And that is how majority of the provisions of the Constitution are changed. Fundamental rights, directive principles, all these are changed using special majority. But then we have the third kind. Those provisions which require ratification by at least half of the states. Those are the federal features. And which are these federal features? Mentioned under Article 368. If you want to change the election and the manner of president's election, you need ratification by states. In a sense, the MLAs of the states also participate in the election of the president. Tomorrow, if Parliament enacts a Constitutional Amendment Act saying we don't want states to be the voters in president's election, this act cannot enter into force unless and until at least half of the states agree with this constitutional amendment, because it's a federal feature. If you want to change any of the lists of the Constitution, first is this 7th schedule, for example, union list, state list, concurrent list. You have to take one item from state list to concurrent list. You need ratification by at least half the states. And that's exactly what was done during the GST. And if you change Article 368 itself, you require ratification of half of the states. If you want to change provisions dealing with the Supreme Court and High Courts, that's why when NJAC was enacted, it was passed by the Parliament by 2/3 majority, special majority. It was then sent to all the state legislatures. And only when at least half of the state legislatures passed a resolution by simple majority approving NJAC, only then NJAC was sent to the president for assent, because that's a federal feature. So some things require so much difficulty in getting changed in the Constitution. That's what we call the rigidity. So our Constitution is a beautiful mix. There are some provisions which are too rigid to be changed, and there are some provisions which are so easy to change, flexible. And that is why the term that is given to the way our Constitution gets amended, that term, that phrase is called flexible rigidity. That's what constitutional experts D. Oliver and C. Fasaro, they write in How Constitutions Change, a comparative study of various amending provisions of the Constitution, saying Indian Constitution is probably the most sophisticated one, in establishing a great variety of procedures to adapt and change its arrangements based on careful selection of different matters. Some matters providing for English to be used in Parliament for more than 15 years can be changed by simple majority. Some can be changed by special majority. Some need ratification by at least half of the states. Otherwise, look at United States. 2/3 of the members in the Congress, they have to first approve a constitutional amendment. Then this constitutional amendment should be approved by 3/4 of the states. And there also they have a restriction that you can't amend the Constitution of United States in terms of their representation in the House of the Senate, where the states are represented. You can't change that. So there is a restriction in United States. But in India, after carefully selecting various matters, some provisions, some matters require simple majority, some matters require special majority, and some matters require ratification by at least half of the states. Let's take a look at prelims question, which you can expect, which was asked from this topic, and by attending this lecture, now you should be able to answer. If you have answered it, if you can answer it, that means you have understood this lecture. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of the bill in the Lok Sabha only. No. The bill can be introduced in either of the two houses, Lok Sabha as well as Rajya Sabha. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all states in India. No. At least half of the states. So this is also incorrect. Question is asking, which of the statements given above is or are correct? D. Neither one nor two. Let's look at the mains question which appeared from this topic. Parliament's power to amend the Constitution is a limited power, and it cannot be enlarged into absolute power. In the light of the statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. You can't do that. But sir, you said about ninth schedule, that a law placed in ninth schedule, there shall be no judicial review. What is the current status of ninth schedule? Listen to me carefully. Vaman Rao case 1981. I.R. Kolo versus State of Tamil Nadu 2007. The combined effect of both these judgments is that if there is a law which is placed in ninth schedule before 24th April 1973, there is no judicial review. Those laws placed in ninth schedule prior to Kesavananda Bharati judgment, prior to the basic structure doctrine judgment, there can be no judicial review. But laws placed in ninth schedule after 24th April, there can be judicial review. As judicial review is part of the basic structure of the Constitution. Clear? But even then, those laws which are placed in ninth schedule, even after 24th April 1973, they still enjoy some protection, which is that these laws can violate Constitution, can violate provisions of the Constitution, but not the basic structure. Normally, if you pass a law, it violates Constitution, the law is unconstitutional. But if this law is placed in 9th schedule, it can violate the constitution, but not the basic structure. It still gets protection. That is the 9th schedule of the constitution. That is it that we had to discuss today in this session, where the purpose was to explain to you how exactly do we teach in our live classes. But if you have any questions, please let me know. I'll be happy to answer all your questions. Law added in 9th schedule after 24th April is open for judicial review. Yes. In Minerva Mills, what happened? 44th Amendment. Or when Article 31 capital C was added to the Constitution by 25th Constitutional Amendment Act 1971, which gave primacy to two directive principles, 39B and 39C, over three fundamental rights, 14, 19 and 31. Then, due to 42nd Constitutional Amendment Act, the Parliament said, if we want to enact a law to give effect to one or all DPSPs. That means previously two DPSPs only were given primacy over three fundamental rights. But now in 42nd Amendment, all DPSPs were given primacy over three fundamental rights. This was challenged in the Supreme Court in Minerva Mills case, 1980. Supreme Court said this is unconstitutional. Why? Because relationship between fundamental rights, or harmonious relationship between fundamental rights and directive principle, is also part of the basic structure. How to specifically prepare for mains? I'm a 2024 aspirant expecting to clear prelims. Answer writing, my dear, focus on your optional, write essays, focus on ethics. Sir, Maratha or OBC previously Nizam Gazette, now they're demanding OBC reservation. How can they be added to OBC category? That is why the Maratha reservation was struck down by the Supreme Court, saying they are not socially and educationally backward. But then something else was done by the government, which I think will not test the judicial scrutiny, will not survive the judicial scrutiny. The law will be declared unconstitutional. Do we have a free course on YouTube for mains like prelims? No, that is unfortunately a paid program available only on the app. Understanding of rule of law is difficult. That is not to be covered here. Our focus only is to cover on Kesavananda Bharati. Maybe we'll discuss that in some free initiative. You can check out my profile on Unacademy app platform. You can follow me on the app, and there we discuss, I take lots of special classes, free classes. You can attend those, and we'll discuss rule of law there. Peter Parker, what's your question, please? Will your classes start from basics or advanced? I start with basics because most of them are engineers who will be attending the classes. Start with basics, then move up and reach the UPSC level. Preamble is not enforceable by court of law. How? Because you can't approach the court and tell the court that the government is not implementing preamble. Because preamble per se is not enforceable in a court of law. Because it's only the identity card of the Constitution. It's the philosophy of the Constitution. But the objectives that are there in preamble are implemented, some of them are implemented through fundamental rights. Those fundamental rights are enforceable. Thank you so much. Hope to see you soon again. First tomorrow at 10 o'clock, where we will discuss the Hindu newspaper, and then in subsequent sessions on YouTube and on the platform. If you have understood this lecture, if you have got some benefit from attending this lecture, please let me know in the comment section. As soon as we will end the stream, please drop in your comments, not in this live chat. After the class is over, in the comment section, please write your thoughts. I'll be more than happy. And please do subscribe to our channel if you haven't yet. Thank you for being with me. All the best. Stay safe.